Welcome back to the deep dive. I want to start today with a scenario that I think keeps a lot of business owners awake at night.
Oh, absolutely.
Imagine you own a simple everyday business.
Yeah.
A hardware store, maybe a gas station, or these days, maybe a cloud hosting service.
Right.
You've got customers coming in and out, transactions are happening, it's all just routine.
Mm.
But then you start to notice something about one of your regulars.
A pattern starts to emerge.
Exactly. The pattern. Maybe he's buying a few too many burner phones every week, or gallons of some industrial solvent that makes no sense for, cleaning a tool. Or at least you are 99% sure this guy is up to no good. He is using what you sold him to break the law.
And that's the moment of truth.
It is. Here's the terrifying question we're tackling today. If you make that sale, are you just a shopkeeper minding your own business? Or have you just become a criminal conspirator?
It is a fascinating boundary. It's really the razor's edge where, legitimate free market capitalism meets criminal complicity.
It seems so blurry.
And honestly, the law here is complex because it's trying to balance two opposing forces. Society's need to stop crime versus the economic need to not force every cashier to basically act like a detective.
That is the tension we are exploring. We're looking at a classic legal puzzle that involves prostitutes, telephone operators, and the very specific mental state you need to be guilty of conspiracy.
The mens rea.
Right. So our mission today is to extract a precise legal test. By the end of this deep dive, we want to be able to look at any fact pattern and determine exactly when a supplier crosses the line from bystander to co-conspirator.
To do that, we're going to be dissecting the doctrine of conspiracy and really focusing on that mens rea, the mental state that's required. It turns out it's not enough to just be there. The law requires a very specific kind of intent.
So let's outline our path. We'll start with the history, see how courts have struggled with this. Then we'll get to our main case, People v. Lauria, and break it down element by element.
Sounds like a plan.
Let's start with the doctrinal analysis then. In the legal world, there seems to be this massive tension between two concepts: knowledge and intent. To a regular person, those sound almost the same. If I know you're robbing a bank and I drive you there, I intended to help you, right?
In common language, yes, absolutely. But in the law of conspiracy, they are worlds apart. And this distinction is really the engine that drives this entire topic.
So what's the difference?
Knowledge is just being aware that a crime is happening or is about to happen. Intent is an active desire or a purpose to see that crime actually succeed.
And that gap between knowing and wanting is where the legal fight is. So, to get the rules for today, we have to look at the tension between two big foundational cases. Let's start with the first one, United States v. Falcone.
Falcone is the bedrock for the defense in these situations.
Okay, so in Falcone, we're back in the days of Prohibition,
No.
moonshine, and you've got a group of sellers supplying just massive quantities of sugar, yeast, and tin cans. Now, obviously, if you're buying that much sugar and yeast in the 1930s, you're not baking a giant birthday cake.
No, you are making illicit alcohol. The sellers absolutely knew. The evidence showed they were fully aware the buyers were moonshiners.
So they knew. But what did the court say?
And this is the key holding. The Supreme Court ruled that this knowledge alone was not sufficient to make them conspirators.
That feels wrong. I mean, they're handing over the raw ingredients for the crime. Why did the court let them off the hook?
Because sugar and yeast are what the court called articles of free commerce. They're innocent goods. They have a million legitimate uses.
You can make bread, candy?
Exactly. And the court was terrified of setting a precedent where a grocer has to interrogate every customer buying sugar. They held that for ordinary, innocuous goods, just knowing about the illegal use isn't enough to prove you joined the conspiracy.
So Falcone gives us the innocent goods protection. You can sell sugar to a bootlegger and stay out of jail as long as you don't do anything else to help.
Pretty much.
Okay, now let's look at the other side of the coin. The case is Direct Sales Carney v. United States. How does this change things?
Direct sales flips the script, and it's all because of the nature of the commodity being sold. In this case, we had a drug wholesaler selling morphine sulfate.
Okay, so morphine is definitely not sugar. It's a restricted substance.
Precisely. It's a dangerous, restricted narcotic. And this wholesaler was selling to a small-town doctor. But they weren't sending him a bottle or two. They were sending him quantities that were, get this, 300 times his normal requirement.
300 times? That's not a medical practice. That's a distribution center.
Exactly. The court looked at this and said, hold on a second. When you're dealing with a dangerous, restricted good like morphine, and you're pushing that kind of volume, we can't just play dumb. The court said that in this specific case, you can infer intent from that knowledge.
So the volume and the danger, that created a stake in the venture.
Yes, that's the phrase they used. The court argued that direct sales had a stake in the venture. They weren't just indifferent sellers. They were relying on the doctor to move this massive amount of product. If his illegal business failed, direct sales would lose their best customer. They essentially became partners in crime.
So I've got Falcone saying knowledge isn't enough for innocent goods, and then direct sales saying knowledge is enough if it involves huge amounts of dangerous goods. That's the spectrum.
That is the exact tension that our main case, People v. Lauria, has to resolve.
Okay, before we get into Lauria, I want to test this boundary a bit with some hypotheticals. I think it helps make it more concrete.
Good idea.
I want to see where knowledge legally morphs into intent based on what's being sold. Let's start with the crooked dice hypothetical.
This is a classic example from the legal texts.
So imagine a manufacturer who makes dice, but not just any dice. These are weighted. They are crooked. They are designed specifically to cheat at craps. Now, if that guy sells those dice to a casino, does the law infer intent?
Yes, immediately. And the reasoning here is crucial. There is no legitimate use for crooked dice.
Right, you can't use them for monopoly with the family.
Exactly. The product itself just screams conspiracy, so intent to defraud is inferred from the simple act of selling them. You can't say, oh, I didn't know he was going to cheat. The product is the cheat.
That makes perfect sense. The product itself is the smoking gun. Okay, now let's raise the stakes, the Molotov cocktail hypothetical.
This one tests the severity of the crime.
Imagine a gas station owner. He sells gasoline, totally legal, just like this sugar and Falcone. But a guy walks in, buys 5 gallons, and starts filling up glass bottles with rags in the neck right there on the forecourt.
Wow.
And he's screaming about burning down a federal building.
A terrifying image.
It is. Now, gasoline is an article of free commerce. Does the owner have any liability here?
In that scenario, yes, almost certainly. Even though the good itself is innocent, the crime is so heinous, we're talking terrorism, arson, a major threat to public security, that the court suggests knowledge alone might be enough to prove intent.
So there's a duty to act.
You have a moral and a legal duty not to arm a terrorist. The severity of the felony just overrides the freedom of commerce in that case.
Okay, so we have crooked dice, inherently illegal use, and Molotov cocktails have a heinous felony. Now, let's contrast that with something totally innocent.
Okay, consider a public stenographer or a registered nurse. These are legitimate professions, right?
Right.
Now imagine a public stenographer gets calls at 2 in the morning to transcribe notes for some shady-sounding guys. Or a nurse gets calls at odd hours to patch people up, no questions asked. The person taking those messages might know something odd is going on, but because the profession itself has a legitimate use, simply taking the call doesn't mean you have a criminal stake in whatever is happening at 2 a.m.
You're just doing your job.
Exactly. Unless you're getting a cut of the profits, you're generally going to be safe.
That sets the stage perfectly. We have the spectrum. Now let's analyze the main event, People v. Lauria. This case is the synthesis of everything we've just discussed.
It really is.
So let's analyze People v. Lauria. First, what are the legally dispositive facts?
Okay, so you have Louis Lauria, who ran a telephone answering service in Los Angeles. The police are investigating a prostitution ring.
Right.
So they send in an undercover cop, Stella Weeks. She goes to Lauria's office to sign up for his service. And she is incredibly brazen about it.
She doesn't hide what she's doing.
Not at all. She tells him her business was modeling. She uses street slang, like turning tricks. She tells him she's worried about the Vice Squad tapping the lines. Lauria just assures her his service is discreet and she'll be safe with him.
And did he know for sure?
Oh, yeah. Later, when the police questioned him, he admitted everything. He told them he knew some of his customers were prostitutes. He even admitted he personally used the services of one of them. But, and this is critical for the case, he did not charge them extra. They all paid the standard rate.
And what was the core legal issue here?
The issue is, under what circumstances does a supplier of a lawful service like a phone line become part of a conspiracy to further an illegal enterprise when he has positive knowledge of that illegal use?
Okay, and what rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
The court established that to prove conspiracy, the prosecution has to show both knowledge and intent.
Right.
Now, knowledge was admitted, he knew, so the whole case hinged on intent. The rule states that intent can be established via three specific pathways, or elements.
Yeah, okay.
First, you have direct evidence of participation or giving advice. Second, you have an inference of intent that comes from having a special interest or a stake in the venture. And third, you have an inference of intent based on the aggravated nature of the crime. Basically, is it a felony or a misdemeanor?
Thank you. So now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, direct evidence?
So the sub-issue there was, did Lauria actively advise or guide the prostitution business?
So is he a manager or just an answering machine?
Exactly. The court compared this to another case, People v. Roy, where an answering service operator actually told the prostitutes where to go, how to dodge cops, how to price their services. In Roy, the operator was basically a business manager.
Okay.
But applying the facts to Lauria, the court found no evidence he offered any advice on how to run the business. He just took messages. So, the conclusion for this element, not met.
Yeah.
No direct proof of complicity.
Understood. He was passive. Now, what about the second element, that inference of a special interest or a stake in the venture?
This is where they apply the gap between Falcone and direct sales.
Yeah.
The sub-issue is, did Lauria profit disproportionately, or did his business lack any real legitimate use?
Okay, and what's the rule for that?
The sub-rule is that intent is inferred if you see inflated charges, no legitimate use for the service, or a grossly disproportionate volume.
And how do they apply to Lauria?
Well, first, he charged standard rates. Prostitutes paid the same as plumbers. If he had charged a risk premium, that would have looked like a stake in the venture.
Right.
Second, answering services have obvious legitimate uses for nurses, actors, you name it. It's not like the crooked dice. And third, the volume of calls wasn't grossly disproportionate. It wasn't like the doctor buying 300 times the normal amount of morphine.
The conclusion for that element.
Element not met. No special interest or stake could be inferred.
That makes sense. He wasn't price gouging them, so he wasn't really a partner. Okay, so what about the third element, the aggravated nature of the crime?
This is basically the Molotov cocktail test. The sub-issue is the crime serious enough to impose a positive duty on him to, walk away?
And the rule?
The sub-rule is that for serious felonies, treason, kidnapping, heroin distribution knowledge alone might imply intent because of the sheer danger to society. But for misdemeanors, knowledge is never enough without that positive intent.
And prostitution is a misdemeanor.
Exactly. The application here is straightforward. Prostitution is a misdemeanor. The court called it a venial crime, or a wrong prohibited, not a heinous threat to basic security like terrorism.
So the conclusion is pretty clear.
Element not met. Because it's a misdemeanor, intent cannot be inferred from knowledge alone.
And after analyzing all those elements, what was the court's final conclusion?
The court affirmed the setting aside of the indictment. Since there was no direct intent, no special interest, meaning no inflated prices or dangerous volume, and the crime was only a misdemeanor, there was just insufficient evidence of a conspiracy. Lauria is not liable.
So he knew about it, but because he didn't do anything extra to help, and because the crime wasn't a felony, he walks free. That is a very, very tight needle to thread.
It is, and it provides a really clear structure for how we should analyze these problems going forward.
Which brings us to the toolbox. If one of our listeners is studying for an exam or, just trying to stay out of jail, how do they apply this?
We can synthesize all of this into what I'd call the Lauria checklist for supplier liability. If you're analyzing a fact pattern, you just have to go through these 4 steps in order.
Okay, what's step 1?
Number 1, check for knowledge. Does the supplier know about the illegal use? If the answer is no, you stop right there. They're not liable. If yes, you go to the next step.
Step 2?
Number 2, check for direct intent. Did they offer any advice, encouragement, coaching? If yes, they're liable. Game over. If no, you proceed.
Okay, what's number 3?
Number 3, check for a stake in the venture. This is the economic test. You ask yourself, are the prices inflated? Is the volume grossly disproportionate? Is there no legitimate use for the good or service? If the answer is yes to any of those, intent is inferred and they're liable.
And if not, there's one last step.
One last check. Number 4, check the severity of the crime. Is it a misdemeanor? If so, knowledge alone is never enough. You need that special intent. Is it a felony? Be careful. Knowledge alone might be enough if the crime is heinous, like terrorism or kidnapping.
That is incredibly useful. Knowledge, direct intent, stake, severity. It really covers the whole landscape.
It does. It forces you to look at the specific facts rather than just the general feeling of helping.
So what's the big takeaway here? It seems to be that the law really protects commerce. even when it brushes up against crime.
That's a great way to put it.
You can know your customer's up to no good, but unless you charge them extra, sell them banned items, or the crime is a serious felony, you're probably just a supplier, not a conspirator.
That's the legal reality. And the court even noted the difference between, say, a moral obligation and actual legal liability. They even suggested that if society wants to stop this kind of thing, they should change licensing laws or create specific statutes.
So don't stretch the old laws to fit new problems.
Right. Don't try to stretch conspiracy law to fit where it doesn't belong. Conspiracy implies a partnership, not just a transaction.
It's a fascinating distinction. And it leaves me thinking about the modern world. We don't really have telephone answering services anymore. We have internet service providers, cloud hosts, encrypted messaging apps.
Right. The scale has changed completely.
In the digital age, does a server host know what its users are doing? And if they do know and they just keep cashing the checks, at what point does tolerating traffic become a conspiracy?
That's the billion-dollar question.
The Lauria test suggests they might be safe as long as they charge standard rates. But I just wonder if that holds up when the scale is global and the potential crime is so much bigger.
As the crimes get bigger and the services get more automated, that stake in the venture analysis is going to get very, very complicated.
Something to chew on. Thanks for diving in with us.
My pleasure.
We'll see you next time.